Good day, everybody. Charles Oppenheim, the chief guy at the State Department, released his visa bulletin presentation today, and had very interesting information about not only this month's visa bulletin, but the next couple months visa bulletin dates and next year as well. And we're going to be discussing all these details for you today. But before we go into that, we are going to go with our PowerPoint presentations. I'm Sam Shihab.
I'm Brian Burke.
And without further delay, jumping into the presentation. First of all, Brian, let's get started.
So the August Visa Bulletin. What happened? The honest answer is not much. So EB2 final action dates, no movement whatsoever. Still on June 1st, 2011. EB3 moved another 6 months from January 2013 to July 2013. Worth talking about the dates for filing just for a moment. They didn't move at all, but ultimately those things are more likely to move and actually be used in October, which is what's on everybody's mind right now.
Good summary, Brian. Furthermore, the chat with Charlie, and we're going to give you a basic summary, and then we're going to break it down in a lot more details after the PowerPoint presentation. But basically, here's what we've learned today. January 1st, 2014, EB3 final action date for September 2021. So for the September 2021 Visa Bulletin, that's the expected date. There is a significant increase in family-based immigration processing abroad, which caused a lowering of estimates of the unused family numbers from the original estimate of 160,000 down 150,000 unused visas. Basically, there is an improvement such that the unused visas, which are going to go into next year, has been reduced from 160,000 to 150,000 visas. And here's the big one. We are looking at approximately 100,000 unused employment numbers this year as wasted because of the pandemic. So the 100,000 that we've gotten looks like most of them are going to get used, will be wasted. Based upon demand, we will not see EB categories become current.
So also covered in this is, per Charles Oppenheim, there's no reason to believe that EB3 India will reach 2017 in the foreseeable future. Now, there's some dispute between Sam and I as to what he actually meant by that.
And we'll talk more about it.
So, in terms of figuring out the movement forward, it's just a matter of comparing cases in process versus demand. Expected no drastic movement in the first quarter of fiscal year 2022, which is pretty big in my book. And here's some really interesting ones. So they don't anticipate reaching 2016 for EB2 in the next fiscal year, definitely. And EB3 is even unlikely to hit 2016. And finally, he said regarding the final action dates for October, look at the filing dates on the September Visa Bulletin. That's going to be a preview, essentially.
Meaning not much of a move between September and October, looks like.
Yeah.
All right.
So the other topic of presentation, traveling with your pending adjustment.
Let's talk about traveling while pending adjustment. It's an interesting topic, and there's a lot there in it, but we're going to make it simple for you, and hopefully we can take questions. So basically, the general rule, traveling abroad while on adjustment of status being pending is an abandonment. So leaving the U.S. while you have a pending adjustment of status, it's an abandonment of your adjustment of status. Remember, the adjustment of status requires that you are in the U.S. while it's pending. This means that the case will be denied or be really considered abandoned. Now, there are exceptions.
Yes. So the big exception is, well, we'll get to that in a second. Ultimately for H's or L's, that's visa holders, that's who it's going to apply to. So there's really sort of two options for traveling when your AOS is pending. Again, using a visa, your H-1B or L visa. Benefits there, you keep your non-immigrant status, and there's less hassle upon entering the United States. Advanced parole, if you have it, there's a bit of a downside there. You can expect secondary inspection. We'll get into that a little bit later. And you enter as a parolee, you abandon your non-immigrant visa status. But also, you don't have to worry about stamping. You don't have to worry about getting an appointment at the consulate abroad and whether they're going to approve your case, whether they're going to ask about your project, that sort of thing.
So with the advanced parole, expect secondary inspection. That's the only thing really is not a big deal. The only thing is don't schedule a local travel, like from, let's say, JFK to Iowa or to Ohio or whatever, the second flight very close to the international flight arrival, because it takes time to process the advanced parole. And then the abandonment is really not a big deal. So continuing traveling while on adjustment of status is pending. So traveling using a visa, only available to H&L visa holders, meaning that if you're on an H1B or H4 or an L1 or an L2, you're allowed to travel abroad and you have not abandoned your adjustment of status. Same process as before you filed I-485. You come back on an H1B or an L visa and you'll be processed in and you'll receive an I-94, and that departure from the US and return does not really affect the continuation of the I-485 petition. If you travel before your advanced parole is approved, recent in the last few years now, that was not the case before, now it is the case that your advanced parole is deemed abandoned, and therefore it will be denied. But you can definitely, if you return to the US on H or L visa, you can just apply for a new advanced parole. And you have to disclose that you have a pending I-485 if you're asked at the border. There's nothing to worry about.
Yeah. So moving on to actually traveling with regard to with an advanced parole, which is new for a lot of people right now. So many people got to file adjustments back in October. The number one thing for me is traveling using your advanced parole. For the last couple of years now, they've been issuing combined EAD and advanced paroles, and you got to make sure that your EAD is an advanced parole. There will be an endorsement on the bottom of your EAD that says serves as I-5102 advanced parole. If you have that, you have an combined advanced parole and EAD. And if you don't, well, you better have a separate advanced parole document, or that means you don't have one.
So don't assume just you got an EAD that you got an advanced parole.
Yeah, because it is possible to get a separate document, green sheet of paper, advanced parole as well.
So what documents do you need if you're planning on entering on an advanced parole? Well, it's the advanced parole card is needed. Your passport, you need to have a passport. Yeah. And then there are other documents we recommend that you have as an added value. Not required, but added value. The I-485 receipt notice, perhaps an H-1B approval, your EAD card, and
get into those questions about returning to work.
Yeah, and just you need to understand. The biggest problem for advanced parole is they are worried about fraudulent documents. And is this advanced parole fraudulent? Has this advanced parole been denied or abandoned or revoked by USCIS? Or the conditions changed, like the I-485 is denied, for example, such that the advanced parole is no longer valid. That's why you go into secondary.
Yeah, so kind of touched on some of these earlier, but these are more issues about traveling on your AP. So what to expect: secondary inspection, you're going to be pulled aside. You're not going to just be waved through. Well, nobody gets really waved through, but you're going to be asked more, like the things Sam just mentioned. And the delays are common. Unless you're a world-class sprinter and you like taking risks, don't schedule quick connecting flights when you're traveling on advanced parole.
All right, traveling using advanced parole. So once you're admitted, you are a parolee, not a non-immigrant. What does that mean? That means you have the right to stay in the United States legally, but you're not on an immigrant status. And it passes on to your children. Now, here's the question. If you enter as a parolee, and we'll probably have that in the discussion, what happened to your H4 family that are in the US?
Well, their status derives.
We'll pause that,
yeah,
and we'll discuss it after the PowerPoint presentation. That trickles down to your family members as well. So you have to use your green card EAD to work, and not your H-1B EAD if you are on a parole, not your H-4 EAD. So if you enter the US, you're on H-4, the spouse is on H-4 EAD, but you enter as a parolee, the EAD you should use is the one that came with the advanced parole, not the one that you got approved because you're on H-4 status. But you can apply to reinstate your H or L status,
Yeah.
which is a good under certain circumstances.
Yeah, I mean, I'm always the guy harping on maintain your non-immigrant status while your adjustment is pending, and don't use your EAD or an AP. Well, you can always apply to get back on it.
Well, how do you apply to get back on it? If you join the original employer and you work for them, then you could, under certain circumstances, discuss that with your attorney.
Yeah.
And they would not consider that you work with unauthorized employment. Let's assume you did not have an EAD, you only had an advanced parole. Back in the days when that memo came out, you would receive an advanced parole, and you would not, which is separate than the EAD. So that situation led to a memo that said if you joined back the original employer and you worked for that employer without an EAD, you could apply to get back on H-1B even though you came as a parolee into the United States. But you could not do it if you use your EAD with the employer or with another employer. Obviously, now that the EAD card and the advanced parole card are one and the same,
less common to come up. But I mean, I've talked to a fair amount of people who said they split up my EAD and AP. I tell them, don't worry about it, but make sure you have them both.
Yes. So, but to apply for a get back on status, discuss it with the attorney the moment you come back to the U.S. or right before you come back to the United States, because you need to make sure that the conditions are right for that.
Sort of closing up here, traveling, there's a couple other considerations out there. One, the many travel bans out there: India, Brazil, South Africa, Schengen area, United Kingdom, and Ireland. Those you can't travel to these countries and then come to the United States in 15 days, excuse me. Travel bans are still in place, and AP holders are not exempt from those. So you have to keep that in mind. Worth noting that non-immigrant visa travel, your H or L, has its benefits. They don't consider parole to be an admission. And again, this falls into the talk with your attorney about it category, but there's this great bit of law called INA 245K that under which you can get excused from a lot of immigration oopses, essentially, and they count it since your last admission to the United States, and parole is not considered an admission. And this reminds me of something. I talk to people right before green card interviews, because sometimes they'll bring me with them as their attorney, and they'll say, "Brian, I did such a good job. I haven't left the United States for 10 years. I'm a shoo-in," And the problem with that is they have 10 years worth of potential immigration oopses.
Potential.
Yeah.
So you have to be careful with that.
Yeah.
Absolutely. All right. So I have a few questions that came in, and please send your questions over on YouTube or Facebook, whatever channel you're watching us on. We will get them answered. But I had a couple of them that came in via email, and might as well knock them out. If I am outside the United States on my green card, and my green card is approved, how can I return to the United States? Can I use my advanced parole?
Outside the United States and your green card is approved.
So while the person's outside the United States, they get this document that says, "Welcome to the United States. Your green card is approved," but they have an advanced parole in their hand. How can they come back to the U.S.?
With great reverence for the customs folks that they're going to be dealing with, or the airline that's going to be your gatekeeper.
So okay, so what you do is the advanced parole, which hangs on the adjustment of status. The adjustment of status petition is no longer there.
Yeah.
So is the advanced parole not valid?
The secret workaround for this one is, who cares about the advanced parole? It's find a friend to go into your mailbox, grab your green card, and send it to you, and that should.
So I have had many of those situations come up in my practice. I've not had a single person that did not receive a permission to enter the U.S. So as far as the airline, if the airline is checking and you don't have a green card, just show them the advanced parole so you can be able, at least, a lot of airlines would require to show a permission to enter the U.S. I would show them the advanced parole document, because those guys, are not going to understand if you don't show them a green card, you got to show them something to get on the plane. But as you land, the moment you go to inspection, you just need to show them a copy of your approved, the Welcome to the United States I-485 approval, and show them the advanced parole at the same time. You present both documents and just say, my green card just got approved. I did not have the card in hand. And by the way, I do have an advanced parole, and I have the approval notice. They're going to look at you like, oh, great. And they are going to take you to secondary, and they are going to check on it, but they are going to let you in. Most of the time, they will issue a I-551 stamp, which is a green card stamp on your passport, after they confirm the information that they are there. And that is going to be really nice. So don't panic if while you're outside the U.S., your green card was approved. I haven't had a single person that never entered the U.S.
It's more of a rather than
yes,
you know?
Yes. So I got a few more questions, but I get also some people questions. So
I want to talk some more about this Chats with Charlie stuff. I mean, we talked about that briefly. I mean, I think
let's talk about Chat with Charlie. Heck with those questions, and we'll get back to it. So I'll take one question from here first to get those guys. I don't want to ignore these guys.
Yeah.
And then we'll go back and we'll go back and forth.
I want to talk about the Visa Bulletin. Everybody loves the Visa Bulletin. You know?
Yes.
So this is for Prashant Kumar. My priority date is February 2016, and I have it under EB2, EB3. Is it a fair assumption that the filing date will become eligible in October 2021? Excellent question. This segues right back into the Chats with Charlie.
Yes.
So
I'll move back to my notes here because
Sam and I about 5 minutes after Chats with Charlie was up, we were both in front of our computer going, staring at it.
Right, and I'm looking at my notes. So what do you think the answer to that? Because I think
Charlie gave us a pretty darn good answer for that.
Yeah, I don't think so, right?
No. He said, for EB2, he said it was pretty much definite that you're not going to see current for 2016 dates to be current in the next fiscal year. And for EB3, it was unlikely. Yeah, and I note him in my notation. It's minute 30 in Chat with Charlie. You can go back if you want to go to Chat with Charlie and minute number 30, give or take. He said no, 2016 EB2, no, 2016. He said 2016 EB3. He said he was definite. They're going to have to go back and check the video, and I'm so glad you timestamped them. But he said definitely no for EB2, but he said unlikely for EB3. Okay. So it was in the realm of possibility. Okay. Okay, I'll take that, viewers, because I just wrote no and 2016, but it is minute 30. Again, you win this game because you timestamped all of your notes, which is just an excellent idea. Well, because I hate to go back, because sometimes I need to go back and listen to it a second time when he says something that blows my mind. And he did say a couple of things that, by the way, first of all, I mean, thumbs up for the State Department for being transparent. That's why I want to go back over this. And this Charlie guy, I love him. He is, if we have 500 of Charlies spread out throughout the USCIS and State Department. I'd like one of them at USCIS. I mean, if I have like 500 of him around, I think the world will be so much more beautiful, and approvals come in and fairness. I mean, he's such a great government official, straight shooter. I love him. I mean, he's doing the same kind of presentation as us. He's taking live questions. There's a lot he won't answer, and we're happy to, on the spot, and he's not worried about it. Yeah. Yep. Absolutely. See, and we have, we started talking about the August Visa Bulletin, right when we started. I wanted to go back and touch on these things. I mean, number one thing, most interesting thing for me, and this is why he's so awesome, he flat out told us that January 1st, 2014, that's going to be your EB3 final action date for September 2021. Sorry, September. He said yes. Yeah. Very affirmatively, he said yes. And I got to point out that, back in, if you travel way back to October 2020, what did they say? What was the dates for filing for EB3? It was 1st of January 2015. And this is kind of blowing my mind. Maybe they were caught totally off guard, but the dates for filing were supposed to be what they thought they would get to within the year. And now it's September, the last month of the fiscal year, and they're saying we're only getting to January 2014. And here's the one that breaks my heart, is he's confirming that the wastage of green cards
is approximately 100,000 green cards.
Yeah, that's the most current estimate.
Yes.
As of this morning.
Yes, as of a few hours ago. That will not be used; just be wasted.
Yeah, and what did you say was the number that the big gold? That's pretty much all the additional visas they expected to be available, right?
I think about 110,000 that he moved over, 100,000 of which will be wasted.
That's
shocking.
I have some four-letter words for that, but shocking is a much longer one.
Well, shocking is a four-word, S-H-O-C-K.
Well, it's a much
longer
longer word and much more appropriate for the context.
It is shocking. Now the appropriation committees.
Oh yeah, this came up.
Bill, USCIS's bill to Congress has a requested amendment to recapture all unused 2021 and 2022 unused and unallocated and wasted green cards. So if Congress acts on that, that will be wonderful. But the numbers, the green card numbers next year will be huge, because they have to accommodate 140,000 approximately normal green cards.
Yeah.
Then they have to recapture, let's say they've wasted 90,000. Let's say 90,000.
Yeah.
So they're going to do 90,000. Then his estimate of unused family-based visas this year. Now that may not go to employment. The 150,000, if they pass this appropriation bill, and also the 100,000 may roll back, and that's why he would not comment on it.
To the families, yeah. Well, he doesn't know what the final bill is going to be like.
So if they allow to recapture these visas, they may shift back to families, to the consulate.
I don't mean to anger our employment-based audience, but I mean it's kind of fair.
Unknown. It's very unknown right now what's going to happen, but there is a lot of things here that's going to be happening this year and next year about this issue.
I mean,
and he wouldn't comment on it. He said, "I have my own analysis. I've analyzed it, but I cannot comment on it."
He said, "I don't know I know what's in the bill right now, and they haven't passed it yet, so that's one reason I can't comment. And what they might pass might not be what I've seen, and thereby I definitely can't comment on it."
Right, but clearly, I mean, it may move back to the family.
Yeah, I mean,
in which case will be a loss for the employment base, anyways.
Yeah, for those of you who don't know, I mean, the whole reason why the whole visa bulletin moved forward in October of 2020 is due to COVID-19. The consulates have been closed. It's why you can't get a visa appointment. Why everything's on an emergency basis, and all those family-based cases, people in the United States, U.S. citizens, permanent residents petitioning for their relatives. They can't. Those folks have been stuck abroad. We have lots of cases, like in our office, where we're just left saying, "I guess they'll get to you eventually." But I mean, I've had cases that have been family cases that have been documentarily qualified through the Department of State since end of last year or before, and they're just sitting there waiting for them to bring in for a final green card interview.
He also confirmed that it will not be a repeat of 2007. Turning everything to current. That will not happen this year or next year. There's plenty of demand that will not allow or would not justify turning everything to current.
Yeah.
Which is, I think it's a lot of people were talking about that.
Yeah, no, there was a lot of chatter.
Yes.
Even during the chat, there were people asking, are they going to be everybody going to be current?
Yeah. So before I bring my next to me, which is a shocker that Brian and I also debating a little bit about. Let's take one more question, and then we'll go back to Charles Oppenheim's presentation and go to the
October Visa Bulletin. The September, August Visa Bulletin.
No, for me, it's the calculation of the EB2 versus EB3. But let's take a question.
Okay, this is from Srinivas. So for August 2021, became current on EB3. You haven't become current yet. You will become current. Current on EB3 with I-140 approved and biometric done. What is the expected time frame that my case will be picked for AID? I'm going to guess just for processing. AID processing?
For processing.
For processing. So this is a conversation I have with a lot of people on the phone. We talk to people, it's how can I get my green card approved fastest, So what I can say is good that from what we see here is you look documentarily qualified, I would ask, he means AOS processing in his follow-up. He means there. So You look documentarily qualified. I would ask the question, did you send medical exams with the adjustment of status? That's something that might impact that. But how long it will be picked? That's a great big question that we don't have the answer to. Ultimately, I talked to a lot of people who, they say the same thing as you. Is my I-140 is approved? My adjustment should be ready to go. What gives? Why haven't they gotten to my case yet? Massive backlog at USCIS. They're trying to, which is kind of just massive backlogs at USCIS. What can you do about it? Sam, what can you do about it?
Scream and yell and lobby, but there's really not much you can do.
I mean, expedited processing requests, but you and everybody else are going to be applying for those.
I mean, what expedited? Unless you have a special circumstance.
Yeah.
I mean, people call and say they want to do an expedited processing, and they insist on it, and we will do it. And then there's all kind of people saying, "Oh, I get the secret how to resolve, how to make an expedited processing is for expedited situations, and it has to be." There's a criteria, humanitarian basis or other bases that are, financial hardship, and you have to well document it.
Yeah.
If your problem is similar to everybody else's problem, stand in line. Unfortunately, that's how USCIS feels about it.
Yeah, I mean, I'll usually close my conversation on the subject. Who are we who you think we can move the entire United States government for one person in their exact,
unless there is a good reason for it. I mean, we've had great cases with people with amazing personal reasons that is justifiable, and they have been approved. But those, I paid an attorney, some money, and now he's going to file the papers. That doesn't get you anywhere.
Yeah, I mean, I can think of somebody. I have somebody right now in my pocket who I think makes a good expedite request. But even then, I say I'm happy to try it for you guys. But we're going to get that green card as soon as you can. But it's.
So back to Charles.
Back to Charles. Yes, our good friend Charles.
Yes. So back to Charles. Yes. So the reason the EB2 India is not moving is because how they count the numbers, the process, the procedure that they count the numbers. One of the problems is that because you have an approved I-140 in the EB2, the fact that you have downgraded your petition to an EB3 does not relieve or open up a spot in the EB2. So if we have 10,000 people applying for EB3 downgrade, it does not open 10,000 spots in the EB2 category, which is nuts.
See, I listened to the same presentation with you. I'm not 100% sure of that.
Well, I'm 100% sure.
100% sure?
Well, I'm 100% sure that it does not open up a spot in the EB2.
Oh, I definitely agree that they're not open up yet. That's for sure.
Yeah, that we agree on that.
Yeah.
Because you filed for a downgrade does not mean they were going to say, one EB2 is available, let's move it forward.
Yeah.
Okay?
Yeah.
It does not do that.
Yeah.
Now, furthermore, where you and I disagree, is it would seem to me that filing under the I-140 may end up being a double counting of visa numbers because you're now filing an I-140 in the EB3 category, and again, you go back and listen to how he calculates the number. He clearly takes what he says, reports on demand from USCIS into the mix.
What is demand? What is demand?
Well, what does USCIS gives him as a report?
That's really what it is. We have no clue.
No, you tell me what information USCIS can give him.
Well, in theory, they can tell him about filed I-140 EB3 downgrades, right? And that's really what demand is. But the question is, does USCIS tell them about those when they're filed or when they're approved? And here's my big. We were talking. Sam and I have been talking about this on and off on all day today. And I'd say, well, can USCIS really tell him to start allocating visas based upon pending I-140 EB3 cases? I guess I said no earlier today. I was saying no, of course not, because they're not approved yet. Then again, they can guess. They can say that a percentage of these are probably going to be approved. They probably received tens of thousands of I-140 EB3 downgrades back in October, and some of those are going to be approved. We just don't know what data that Charles Oppenheim gets.
So only when he said only if the I-140 is approved will he remove one number from the EB2 to to the EB3. And that's also a mistake. How about if you change your mind and you went back to EB2?
Interfiling. Yeah. Yeah. I mean, we were all left with the impression that the way the Department of State, or the data that he gets, and how it just seems crazy, the data that he gets. Like they're giving him bad information that's hard to act
upon. Well,
it's
not bad information. With all due respect to Charles and his many years of experience in allocating these numbers, it's just a method of calculation leaves a lot to be desired. Yeah. What if not interfile? What if you file double adjustments? What happens?
Well, I would say it seemed that they just have to sort of hold two slots for you until one gets approved.
So the whatever method they're using is really does not comport to actual reality of how the cases are handled. It creates a disconnect between what's really happening out there and how he's counting. He's counting beads, he's counting numbers, and he's coming with projections, but the reality is different.
Yeah, I mean, so to summarize again, I mean, you're talking about a scenario where they're essentially double counting people, and that means there could be way more visas, visas available. And I'm sort of left thinking, they're single counting people, but they're not moving those beans from one column to the other when they should. Meaning, see, here's what I've been thinking. I've been wondering this for a long time, whether or not, EB2, when they start approving these we'll see the answer. If they start approving these EB3 I-140 downgrades, eventually, in theory, you should see the EB2 category finally start catching up to EB3. Its space will be taken up in EB3, and no EB2s are being used.
What I think is a solution to that, and it's simple, is what the State Department a decade ago recommended that USCIS refused to abide by, is take all cases based on date for filing, not final action. You take them all date for filing, so now you have a bunch of cases, and then as you approve green card, you count. And that's easy.
Yeah, and
life is easy that way.
It's better for everybody because people get the benefit of having those pending adjustment of status. I mean, the big great thing about the dates for filing is you get to file your adjustment of status early. You get the benefits, EAD, AP, stay in the United States per your pending adjustment, and that's good for everybody. Yep. It gives some stability to everybody's lives.
So what else drove you crazy about the numbers?
So
he was asked, will EB2, once somebody asked that EB2 India moved, and this is minute 44, by the way, and 48 seconds. If you guys want to go back and listen to those on the tape, that you don't have to listen to the whole 45 minutes. They said, he was asked, would India move 1 year, 9 months next year as it did this year? And he would not commit to that. He said he's not sure that even India would, EB2 India would move 1 year, 9 months next year. But I think he's wrong, in my opinion, because he doesn't have visibility on approved I-140 in the EB3 category.
I mean, again, I'm kind of paranoid that EB2 will finally move.
And he was asked, would India be in the 2017 date in this year in September? And he said, absolutely not. It will not be 2017 in September.
Yeah, I mean.
And then also he said, no drastic movement. In the first quarter.
Said, no drastic move expected in Q1 of fiscal year 2022.
In the first quarter,
I'm my notes.
Yeah, in the fiscal year of 2022.
So that's October, November.
So
So
cool. So are we moving at all? What the heck?
I mean, again, I'm driven nuts by the fact that they told us in October they expected to get to January 2015, and they're only going to make it to January 2014 in terms of final action dates. I don't know how.
But he also said that USCIS most likely go to filing date in October instead of final action date.
Yes. Which happens every year.
Most years it happens, looks like, which means that there may be some adjustments filed.
At the very least, some more people might get to file for it.
Yeah. Well, let's take another question.
More questions, please.
Yeah, let's take a question. And then also I'll take those questions, some of the questions I have here that I got by email.
So this is from Radha. So my EB2 priority date is February 15th, 2011, and received EAD and AP. What's the next step in the GC process? So, people.
Great question.
I think it is a good question. Well, you think it's a great question. I think it's a good
Be
question.
patient.
Yeah.
Wait. 2011, February. It's a matter of getting to you. I mean,
Yeah, well, I want to just kind of dispel a myth. People always ask me and say, well, I finally got my EAD and AP, and that means they can approve my green card right now. They're not. They could throw your EAD AP in the garbage and approve and you'd be happy if they approved your green card before that, and they can do that. There's no requirement they approve your EAD and AP before approving your green card. It's nice that it happened, but I've talked to the occasional person who gets that green card before the EAD and AP.
So final action date is June 2011 right now for India's second preference.
Yeah.
So February, yeah, sure.
Yeah.
So it's just a matter of getting to you.
Yeah, they just have to get there.
Do you have your medicals? Do you have your updated documentation? So get ready for that if the medicals.
Yeah, I mean, and maybe this means Red Hat's in the EB2 category for the adjustment, but I ponder if somebody filed an EB3 downgrade back in October, and probably not, because I think that date might have been
EB2 February 2011.
Yeah.
So and looks like So it looks like he's filed in the EB2. He's staying with the EB2.
Yeah.
How about another travel question here?
Yes. Travel. The other subject today, aside from August Visa Bulletin, chats with Charlie.
Travel while in adjustment status. So here's another question we got. Family and I have filed adjustment status. We all have EADs and advanced parole. If during my family travel abroad I lost my job and I'm on my H-1B grace period, so family and I have filed adjustment status while we all have EAD. If during my family travel, so he's in the U.S., well, he or she in the U.S., but they lost their job and they're on 60-day grace period, don't have another job, can my family enter the United States on H-4 or advanced parole?
Oh, definitely on advanced parole.
Definitely on H-4.
Yeah, I mean, they're still not considered. I mean, if you go read the 60-day grace period policy,
it requires a job offer, right? So,
no, well, the 60-day grace period basically says that an interruption in employment does not mean you're in violation of your.
But
coming back to you don't have effectively a valid H-1B approval notice. I see your point.
Yeah. So well then. I don't think the abandonment of if the person lost his job, he's no longer on H-1B. He's here in the U.S. They're here in the U.S. The family, are they on H-4 now, or have they abandoned?
Well, if the primary person is entering on advanced
well,
parole.
the primary person is in the U.S.
Oh, entering.
His family left.
Okay, so he's still. Oh, I understand. Okay, I understand. So he's still.
It's a good case.
Oh yeah. So, I was very confused why you said yes for both of them. He's still in the United States on H-1B status because he's in the 60-day grace period, so they are allowed to come in on.
But there's no new petition filed. He's on grace period, but he hasn't filed a new petition.
Families that doesn't require the family.
Is he on H-1B, valid H-1B during the 60-day grace period without filing an H-1B? Transfer is the question. That's really the legal question. Well, he lost his job. Mm-hmm. Now you are deemed to be in grace period, but you're deemed to be in status if you filed an H-1B extension.
Well, you have to file an H-1B extension within the 60 day.
He has not filed an H-1B extension yet.
He's still in H-1B status. His I-94 is considered valid. They'll let his
that's
family
your
in.
answer.
I'll
take that answer.
In, and it's obviously his responsibility to find a job within the 60 days, get that case filed, and
can they come back on H-4?
Yeah.
Can they come back on advanced parole?
Yeah.
Which one would you use?
Either or, honestly. If I had to pick one.
I would go in and try to come in on H-4 first.
Yeah.
And present the H-4, and I don't think it will be a problem.
I don't think so. I think their main concern is who's this guy? Is you're related to him? You got H-4
so
pieces?
on day number 61, he is in the U.S.
You should not be coming in on
I would get my family in during the 60-day period regardless. You
Yeah.
lose your job, and you're on H-1B, and you call your family and say, come back, I lost my job because after 60 days, I don't know if I can get you back in the U.S. Yeah. And you bring them here, let them come in. But Yeah.
This brings up all sorts of questions. I'm thinking about his I-45 portability. How long has this adjustment been pending?
But that's the travel question.
Yeah.
Right?
Yeah, we're on travel for that.
Yeah, well, that's the travel question. So there's a lot more questions to that one. That's a good one. All right, so all right, moving on. Let's take one from today. I get a few more here. Looks like we're running out of time, but so I want to take as many questions from people that sent today. But with all due respect to those who also send me emails.
This is a question, and I will try to give it the tone that it is in. The I-45 processing time sometimes says 10 to 50 months for some processing. Are you kidding me?
Yeah, they're not.
I tell those numbers to people on the phone, and they usually give me 4-letter words back. You know, I mean that's the backlog. That's the thing. You know, you're saying people tell me my case is qualified, and I say, well, yes, in theory they can approve your green card right now. But look at these dates. You know, that's why you can't put in a request with USC and say my case is out of time, because most people, you know, my adjustment was filed in October. It's been what 8 to 10 months right now. I'm bad at counting on a calendar, but 10 months, about 10 months. You know, so that is what it is, and I mean that's the number that really infuriates me right now. There's so many people out there, Sam, that could have a green card in their hands right now if the government wasn't so incredibly far behind.
Well, I mean, you get COVID too. I mean, part of the problem is to begin with. Well, let's face it. One, it's a slow-moving organization to begin with.
Yeah.
Two, we really had tough 4 years with a prior administration that was really not catering.
They were happy to slow things down.
They were not catering to moving things expeditiously. Let's put it that way. Putting it in a very polite way. And three, you got COVID.
Yeah.
I mean, it's a lot.
I mean, who knows how the big service centers are working right now, but it's big spaces with tons of people in them, you know?
And honestly, this administration hasn't been aggressively on top of it. We don't have a USCIS director yet. I think they just appointed one or recommended or proposed one to Congress to approve 2 weeks ago. Come on, get going, man. We need leadership to get things moving.
Yeah.
So yeah, are you kidding me?
They aren't kidding you. It's a very serious number, and it's what's keeping people away from a green card.
Yeah.
You know, Sam, in terms of what can you do about it? That's the thing that it's nothing one person can do, but I just imagine some talking head on TV saying it takes the government how long to process one of these green card applications for legal immigrants?
Yes. Yes, absolutely. My priority is current in the EB3. Can I change my USCIS address to employer? I think, can I change my employer, right?
I think it's, well, let's see, since I might
move to travel trailer, I'm picking up Thursday after lease and on end.
So it's about changing address, it seems. So, the basic.
Okay, so so he's like in between. Just do 2 AR11s. Because you have to do it within 10 days.
10 days of moving. That's it. Yeah.
I would do it twice to be 100% protected because it is an inadmissibility ground.
Well, yeah, but I think he's asking, can you change your USC address to his employer's address though?
I see.
Yeah, I would.
No, that's not an address.
Yeah, be honest. It's where you live. It's where you go home to sleep.
But he said I might move in a trailer.
Yeah, like get an RV or something.
Well, so i.e. he does not have a mailing address.
You might if you have like a place to park it.
Don't go on a trailer, buddy. It sounds like fun though. Being on a trailer is a lot of fun. I would like to be on a trailer, but you have to have a mailing address. You may designate the nearest friend's address as your residential address.
But they're going to want your physical address where they can poke on, knock on the door and find you. That's the whole point of it.
Well, it's a trailer has wheels.
Yeah.
So I think the best you can do is the nearest possible. I don't think changing it to employer is a good idea because an employer is not a residence.
Yeah,
I think the nearest friend's address or the near. He doesn't have an apartment. He's going to be. You gotta have to have a current address, dude.
Yeah.
If you want to be 100% compliance.
Yeah,
you gotta have to.
They unfortunately, as a non-immigrant in the United States, life is a bit harder. And they don't want you to be transient. They want to be able to find you.
Yes. What's up with those laid-off questions? I have one more here. Let me jump in on this one.
Okay.
So if during I think we may have answered that one. If during my travel, during my family travel, I was laid off, and I'm not on H-1B status. Can my family come back on their advanced parole?
You have a pending, presuming you have a pending
So
adjustment.
they have the advanced parole.
Yeah.
Losing the I-485 employer does not negate the validity of the I-485 yet.
Again, we're not going to get into them because they're travel questions, but it raises all sorts of questions whether your adjustment can survive this, because
there has never been a USCIS directive that says if you've lost your I-485 employer, your adjustment status is deemed abandoned.
Yeah, yeah.
And therefore, his adjustment of status is valid.
Agreed.
Do you agree to that far?
I agree. I agree that far.
Therefore, the family adjustment of status is valid.
Agreed.
And therefore, the advanced parole that hangs on the adjustment of status is valid.
It's valid.
And therefore, yes, the answer.
And therefore, I'm not going to go into all those interesting questions about job portability and finding a new offer of permanent employment.
Okay. Well, we can. Let's talk about it for a minute.
So, I mean, anytime somebody says, I lost, we did a whole, this is last week's topic, you know? Anytime somebody says, I lost my job while my adjustment's pending, it basically, I ask, what's the impact on the adjustment?
So he's looking for another job.
Well, there you go.
She can come back, or he can, his spouse or her spouse can come back.
Yeah.
So it doesn't change the fact.
Yeah.
An agreement. Good.
Definitely finding, you know, generally speaking, finding a new job is good advice, though.
Good. So we'll take one more.
We got live questions here.
Yeah.
So here's this one. So I did a downgrade from EB2 to EB3 in October 2020. My priority date is April 10th, 2013. I got my green card EAD and I-140 is also improved.
Oh, wow.
My date is current. When can I expect my green card?
So October, April. So my priority is April 10th, 2013 in EB3. So right now they're doing July 2013.
Yeah, so I mean that's a current date.
It's current. It's a matter of getting to your file.
Yeah, any time between now and go to the USCIS website. They post processing times based upon local field offices, how long it takes them to process a case. Now, granted, not all employment-based cases get transferred to a local field office because they're employment-based cases. They don't usually bring people in for interviews. But that's how you get an idea of how long it's taking to process a case.
Right.
And per our friend who earlier asked the question, anywhere from 10 to 50 months.
Yeah. So
what is that for?
You need to wake up every day and pray, so somebody can grab that file and process it.
Yeah, it's really a roll of the dice as to.
Yes. That brings me to something that Charles talked about today.
Friend Charles.
Which is how they grab a visa number. Remember that part?
I'll admit I wasn't paying attention because I don't care how the sausage gets made, as long as I get to eat some.
Well, because I saw it before, I saw it time and time again before my eyes. They would go in and they would go to a different system. Another computer. I mean, this is back in the days. Probably they combine them in one computer now.
I don't know. Separate agencies. Maybe it's a Department of State computer system.
They will send an email, and they request a number, and they will get an immediate response back confirming that, and then they will just say okay, and then they will approve it right now and claim a number when the case is ready to be approved. And if the number is retrogressed or unavailable, because obviously
I did hear this part, yeah.
It could, I mean, not right now, but it could retrogress halfway through the month. So let's assume there's a.
Oh, he talked about all sorts of when retrogression was likely to happen too. Mm.
So let's assume there's 4,000 visas available that month, and when he walks to that computer, visa number 4,000 has been claimed by another office in another city. So you'll send an email to the State Department, and they will come back and say, no, don't issue this visa. We're going to put it on the waiting list for claiming immediately if the next time it's available. So they can deny that if that number is not available even halfway through the month. So that was an interesting point. Not to you, of course, but to me, I found it to be, the mechanics is interesting to me.
It reminded me of a scenario. I mean, we've seen them actually oops this before. I remember a couple years back, we had a case where they issued they approved people's green cards, and they said, oops, we didn't have green card numbers available for you, and they took them back. Miserable.
Travel question. I am on an F1 student visa and have a pending adjustment of status through my father's employment.
Your father's employment?
Yeah, his dad. The kid is in college.
Oh, geez, okay.
He's on a student visa, and he has a I-45 filed for him. and he has an advanced parole. He travels, he leaves, he travels, and then I return to the United States on advanced parole. Am I able to return to school? Can he go back and work? Go back to school, pick up courses again?
Well,
he's no longer on F1.
Yes, but he is allowed to stay in the United States, and he can go back to school as long as the school is willing to have him.
Well, it's not up to the school. It's not. They don't choose. It's what rights does he have?
Well, yeah. Well, he has every right to go back to school.
Is a parolee permitted to attend school in the U.S.? That's the question.
Yes.
Right?
Yeah.
I agree. I agree with you. Can I stop going to school?
Sure.
So they can do anything they want.
You're going to anger your father, but
that's right. So they can. You can go to school. You cannot go to school. But if you go back to school, you need to go to the International Student Office and say, I return to the United States. I am a parolee. Probably contact an attorney, get a letter of interpretation from your attorney that says, here's the regulations, here's the law that supports that you are allowed to continue your studies in the U.S., so you can hand that to them at the same time before they make a decision trying to overcome if they made a negative decision based on an interpretation or something.
International students, I mean, they're usually well-intentioned, but sometimes they can get the immigration stuff.
They're very smart people, by the way, and very knowledgeable. I mean, everybody I meet, but also they can make mistakes. Good. Let's take a question here from.
I want to get through all these.
Yes.
We'll try anyway. So priority date September 2014. EB3 downgrade receipt date is October 26, 2020. Receipt date for inquiry for I-140 is now November 12th at Texas Service Center. Can I raise a request for outside normal processing for I-140? Sam, can they?
You can definitely can, but has it been within 60 days?
Wait, 60 days?
Usually 60 days beyond. When you're more than 60 days, that's when really they're willing to.
I have usually had no problem, putting in the day after, but.
Well, the question is, what are you going to get back?
Well, see, my trick answer is can I do it? You cannot do it, but your employer can do it.
It's a good answer. Yes. Yeah. Well, yes. Can I? I think this meant can my employer.
Yeah.
But that's a good point to raise.
It is. It's I-140 is an employee controlled employer controlled process.
Yes.
And what kind of response have we been getting for those service inquiries for beyond processing times? Yeah, we'll get to it. Yeah, we'll get to it.
Yeah.
Who are we to think we can make the U.S. government move any faster than it wants to move?
But I did have a service request the other day. I mean, sometimes they work. I mean, I had a service request on a fingerprint. Spouse get the fingerprint, but the beneficiary did not. Primary beneficiary did the service request, and they got it right away. Mm-hmm. They mailed it, so that's not bad. All right, so let's get to a couple more people. There's a few more questions here on travel, but let's take care of people here.
So my EB3 downgrade has been filed in October 2020. Fingerprints done, but approvals are pending. Will there be any impact if my address gets changed, or I just update the new address on the USCIS website? So it sounds like a change of address while your adjustment's pending.
There's no impact. There shouldn't be an impact.
Just make sure that you enter in all your, it sounds like your EAD and AP aren't approved. Your EAD, your AP, your I-45.
But let's give this question a little bit more attention.
Sure.
So you're close, you're moving. So let's look at this. So filed, what's the priority date? My EB3 downgrade has been filed to, there's no priority date.
Yeah.
I don't have a priority date. But let's assume your priority date is really, really ripe for processing, really ready. Mm-hmm. Can you delay your travel? Relocation? Moving around? I mean, can you hold on a little bit? But if your priority date is not ripe, yeah, sure.
It shouldn't stop. I mean, changing addresses should not stop USCIS from approving your green card.
But I wouldn't. If you're ripe and you can stay where you are.
Yeah, I don't want them losing your green card in the mail. I mean, I wouldn't want them losing my green card.
Well, I don't want them to also delay processing because there's an address change, and now they have to check or confirm: is there an employment change of the address where
That's a good point.
It can raise all kind of questions potentially. But if the green card is not ripe, so your priority date is not current or very close to the line, there's a lot of people ahead of you, I would definitely update it. But under any circumstance, don't not change your address if you move.
Don't fudge the numbers.
Yeah, exactly, because life is too short and you're so close to the
green
card.
It is a crime. Yeah. It is a crime to not update your, anybody who's not a U.S. citizen.
It's an admissibility grant for,
That's so
Which is-
not
which-
doing it is yeah.
And back in 2011, in fact, they have deported some people.
Yeah, it's not something that they don't have squads of police
Absolutely.
going afterwards. But can NBC issue green city without interference from FO? So National Benefits Center issue a green card without interference from FO.
Office. O is office.
Yes.
F, I have no idea.
Field office. Field office.
Okay.
Yes.
Oh, yeah.
Yeah, they can.
100%.
Employment-based cases, most of you guys aren't going to get a interview, and it'll go from your case will be updated, say green card approved, card in processing.
Yes. All right, so I got a question here. Travel question.
Okay.
I think we've answered that. Will my pending adjustment status advance parole be denied if I travel abroad?
Your pending advance parole? Yes, most certainly.
Yes.
They will issue you an RFE or a NOID and saying, "Oop, we found out you traveled."
Yes.
As long as we're right, we're going to deny your case.
Okay, so that's a great question right here. Does advance parole guarantee admission to the United States? No. And this is really important for you to understand, guys. It does not guarantee you admission. If you have other problems that will be flagged, criminal background, unlawful presence, and we can talk about unlawful presence, which means you violated your status for more than 180 days, advanced parole will not save you. I know for the longest time that we highly do not recommend you file advanced parole without EAD, because if your H-1B got dropped by mistake and you work without authorization for over 180 days, then you may have accrued unlawful presence. That's not curable. So that's really important.
Yeah. Got more questions, and I think I'm going to like this one. It's all about the Visa Bulletin. So please share your thoughts on the October 2020 Bulletin priority date and the filing date chart where October 20, where 1/1/2015 for EB3 India will become final action date in October 2021. So
we're talking about the projection into the future, and what Charles said. Charles said, I think it's going to go back.
Go ahead.
Yeah, no, you go ahead. But I'll look up the date here.
Well, I mean, for the record, we know that he said that January 1st, 2014 would be the final action date, EB3 for September. So the question is, will they get back to 1/1/2015 for EB3 India?
Well, I think the assumption maybe is that the filing date is a 6 months to 12 months forward look.
Yeah.
And therefore, the filing date will be somewhere between June 2014 to potentially January 2015 projection.
That's what they said in October. That's essentially what the final action dates in October said.
And because he also shared with us that most likely USCIS will take filing dates in October. So it is potentially possible that somebody with a January 1st, 2015 priority date can file an adjustment status in October.
I mean, what did we hear? What did we hear from Charlie during this thing? We heard definitely wouldn't get to 2017. EB3 likely wouldn't get to 2016. So it's indicating that it will get to somewhere in 2015 would be the most likely answer. Sometime middle towards the end of the year, which seems to be a conservative date.
And this information is fresh off the press.
Yes.
Today. A few hours ago, he released it, and you're hearing the analysis from us. So we have to tell people to, don't forget to subscribe.
Subscribe, yes.
Subscribe to our channel so you can get the most up-to-date information.
We do these things every week, and we have a hoot every time. And Charlie was so nice as to just drop a great big bucket of content for us.
And we'll bring it to you whenever we get it.
Yeah.
Every Monday.
Yeah.
All right. So moving on to another question.
Yeah. Oh, that's a good one. That's a forward-looking, optimistic one.
What are the immediate steps after receiving the green card? Send a big, nice present to your immigration lawyer.
Oh, I was going to say crack open a beer.
He may not drink.
Okay, I don't drink either. Either, but
Immediate steps after receiving the green card is probably, I don't know, take your family out, do something wonderful. No, let's address the question. What's the immediate steps? The H-1B visa disappears.
Yeah.
You're now an immigrant.
Your employer
permanent
there's nothing to do. I mean, if you want to update your I-9 record with your employer,
inform your employer that you received, and really nothing to do.
Yeah.
That's the thing. You'll have
welcome
so
to
much.
the United States.
You'll have so much free time. You don't know what to do with it. You cannot. You don't have to be on our stream. You're welcome.
Yes.
Maybe we'll bring you as a guest. But yeah, life is easy.
We're going to keep on going through those questions. So EB3, June 2016 priority date. I have my I-140 approved. What are my chances of getting EAD this year? So my question for you, Kishore, is would you have filed your adjustment? You didn't file your adjustment because your priority date didn't get up to we didn't get up to that point in October 20.
Not based on Charles' projections.
Yeah, I mean, let's say there seems like there's a reasonable chance. Well, it said it's possible. It's
not
unlike,
EB2.
He's EB3. He's EB3. Yeah. So it says it's unlikely we're going to get to 2016, but possible.
No, he said no for EB3, possible for EB2.
Right?
Or do you have it backwards?
Yeah, backwards. My notes say definitely not for EB2. Definitely not getting in 2016. EB3 is unlikely.
Possible, unlikely. Okay.
But I mean, you're in June. You're in middle of 2016. I don't see it happening.
Unlikely.
Yeah.
I'm going to give you Charles' answer. Unlikely, he said.
Yeah.
Yeah.
So, a little bit of follow-up. Does address change need to be reported after green card is received?
Oh, what a great question.
Yes.
Yes. 100%. That's a great question. 100%.
Not until you're a U.S. citizen. How long to become a U.S. citizen? 5 years of holding a green card. 180 days, I think it is. Before that, you can apply. But
90 days.
90 days?
Yeah, 90 days you can apply.
Yeah.
And you have to maintain 50% of that time physically in the U.S.
Yeah. The only way to get rid of that requirement is U.S. citizenship.
And 6 months. Do not be outside the United States for more than 6 months.
Yeah. Going to keep on going because we got some more questions, and we're going to try to get to anybody who gets a question within our time, I think.
My priority date is January 2012.
Biometrics completed.
Congratulations. EB2 to EB3 I-140 approved.
Good,
wonderful.
lucky.
EAD, advanced parole receipt, fantastic. Not filed medical. Okay, my case is with the National Service Center, and derivative cases in the
it's the
which one escapes me? I was looking at it today. I was looking on a case for an MC yesterday. With MC.
It's I forget what the official name for it is. That's the National Benefit Center, right? In Missouri. I think so.
Yeah, maybe.
Yeah.
When can I expect RFE on and green card approval? Again, prior to 2012, in the EB3, right now they're having July 2013, so he's in great shape.
A current year and a half current.
Yeah.
And when can you expect it? Whenever some guy gets a cup of coffee in the morning,
opens a file.
Yeah, and it says, "Oh, there's G-Bond's case."
Yeah.
Yeah.
Go get a medical done. And get 2 copies, negotiate to get 2 copies, one with you, one sent to USCIS with a letter, and just trying to preempt the RFE.
Yeah, you can always try to preempt the RFE.
It's valid for 6 months, so...
Well, valid for 60 days.
60 days.
60 days from the signature.
2 years after, yeah. 60 days from signature and 2 years if they receive it.
Risk in doing that, but I mean, that's one way to avoid the RFE. But ultimately, can you convince them to drag your file out because you sent medical exams? Great big question mark.
Yeah. Or wait.
Yeah. Wait, they will, that's my conversation closed. They will get to you eventually. It's their job. They're required to. They're an absolute mess right now. They're backlogged, but they will get to you.
My spouse is on H4 and have a pending I-140 downgrade. Can she travel between September 2021 and February 2022? Period. Well, she's on H4. Your I-140, I'm assuming everybody got an adjustment of status. I'm assuming everybody got an advanced parole, or you don't have to have an advanced parole. You have a valid H4.
Yeah.
Nice to have an advanced parole.
Well, I don't know if she says she is on H4. She might not have an H4 visa because, it's already been a year and a half since anybody could really travel that much. And it's hard to get an H4 visa right now. Consulates are still closed.
So, okay, so if she has a visa, get an advanced parole. If she doesn't have a visa, get an advanced parole.
Yeah.
It doesn't matter, get an advanced parole, but if she does not have an advanced parole and she does not have a visa stamp, obviously you're going to be at the mercy of the consulate to get a visa stamp to return to the U.S.
And I must say, I mean, do we know when the various travel bans, international travel bans, are going to be lifted?
And are you subject to any of the exceptions? If
Yeah,
you are
that's
if
true.
you have children who are U.S. citizen, born in the U.S., you're subject to the exception.
They meet the immigration definition of a child. Yeah.
Yes.
Yeah, so
under 21 and unmarried.
Yeah.
Then you don't have to worry about the ban. So those are the considerations.
Yeah.
Good questions. My spouse is on H4, and I have a
same question.
Same one.
It's a duplicate.
Right. My wife applied for an H4 EAD extension in August 2020 and have biometrics for H4 in March 2021. Her H4 extension was approved in May 2021, while the EAD application is still pending. That's nuts, right?
Yeah.
Well, that's too bad. Yeah. She again received biometrics appointment for the EAD in this month.
I think we have a bit of a follow-up here.
I don't see it.
I don't see it. Well,
why don't you unhide and see if you can read the rest of it, because I think it's too long.
here we are. I see.
So your vision is better than mine,
Yes,
too.
I was under the impression that biometric step was removed for H4 and EAD. Did something change on biometrics for H4 and EAD? Yes, they did basically undo the biometrics requirement rule for H4s and EADs. That might be your challenge there. Ultimately, well, here's my answer: is USCIS sends you a biometrics notice.
Take it.
Who am I to think I can convince the government to do something it doesn't want to do?
Don't rock the boat. Just take it.
Yeah.
Well, why would you want to not take it? Absolutely take it. Yes.
Yeah. I mean, yes. Generally speaking, they have lifted the biometrics requirement for H4 cases, but you have it. You got to do it.
Yeah.
If you don't go for biometrics, they can consider the case abandoned.
Yes.
And that would be the painfully, incredibly long processing time your experience lost.
So I have one last travel question. What time is it? 7:07. Can advanced parole cure unlawful presence? That's a heavy-duty question. No.
No.
Advanced parole does not cure unlawful presence. What is unlawful presence? If you're in the United States and during your stay in the United States violated your status for over 180 days, worked without authorization over 180 days, worked without a visa without over 180 days, and accrued what the law calls unlawful presence, you are excluded from coming back to the United States for a period of 3 to 10 years, depending on the duration of your unlawful presence. 365 days or more is 1 year, 10-year unlawful presence. Advanced parole does not cure unlawful presence, and therefore you have to make sure that you are in valid status or have not violated your status during your stay in the U.S. for the advanced parole to work. And with that, I think we've gone beyond the 1 hour. Don't forget to subscribe, guys. If you want to contact us, our contact is in the description below.
We got to mention, we do read the comments we get on YouTube, because it's interesting, because we leave these things up. These are live streams, but if anybody has, we come back and look at these things later, and we may not, we're not there to answer them live, but we can, tell us about it, and we'll maybe hit it the next time we.
You put in a comment or a question on our channel on YouTube, you will get an answer within 24 to 48 hours.
Yeah.
Thank you, guys.